for medical conditions that it could be schizophrenia.
When writing a will, we need to ensure that the person is of sound mind, right?
Yes.
But in life we are often hit with unfortunate circumstances. Like
Mm.
one might fall ill, diseases
Mm.
like dementia, amnesia, or
Mm.
maybe even cancer could affect people.
Mm.
So when they are towards the end stages of life, maybe,
Mm.
or
Mm.
when they are nearing to the end,
Mm.
what can the family do to ensure that the will is in place, or how can maybe a person who is not capable of being in sound of mind, like someone who might have dementia, uh,
Mm.
how will they be able to pass on their wealth?
My sense is that you will have to be of sound mind, and for medical conditions that it could be schizophrenia. So in the periods of sanity, when the person is of sound mind, he can definitely write out a will. But otherwise, one of the essentials of even any contract is that you have to be a person of sound mind. So that is definitely something which could be grounds of a challenge tomorrow. So in case there is, it could be set aside, and one of the mitigants there would be to write the will early. While you are in a condition and senile decay has not set in. So write a will early, update the wills regularly. Like I said, there could be additions,
Right.
subtractions to the family by way of death or births. So keep updating. Get a medical certificate. Have that in place so that tomorrow there
Mhm.
is no allegation that you were not in a medical condition
Right.
to record it. And there is also possibility of making a video recording. While you're executing it, please also have a video recording. There is sufficient technologies that have come up, and get it drafted effectively by a lawyer or a financial advisor, and have it witnessed properly. As long as these measures are there, definitely it will take care, and do not keep it for the last stage. Where senile decay has set in, and this could become an impediment.
Right, right. So, just one last question, follow-up question I had. Like, what if uh, can the person say that, okay, in case I am not in sound of mind or whatsoever, and they haven't been maybe able to decide how they want to pass their will on, can they
Hmm.
put that decision off to another family member, or does it have to be someone who is not related? Does it have to
No,
be a lawyer?
unfortunately, you will have to write your own will, and nobody can dictate your will, so to say. But what happens is that in case I were to die today without a will, then what happens is that you will have the personal loss. So you have interstate succession, which is a succession where the person dies without writing a will. Where in such cases the personal laws would take over. Like I said, if I'm a Hindu that's dying interstate, it will be my first class heirs that will have a right on my assets, and of course the liabilities. So and for a Hindu male, it is the mother, wife, and the children. So each will, and of course pre-deceased children, so on and so forth. But yes, thumb rule, it's mother, wife, children that will inherit equally from the assets of the family.